Hey everybody, it's John Michael Bailey, John Michael Bailey Injury Lawyers. Let's talk about something that comes up an awful lot in car accident cases, and that's the issue of comparative fault. Let's talk about what it means and how it might apply to your case, and we can talk about the differences from state to state. Here's the thing to remember. Even if you're partly at fault, you can still get paid. So let's talk about what is comparative negligence, and let's break it down into just plain everyday English. The insurance contracts aren't written in plain English. A lot of the phrases in law aren't in plain English, and that works as a disadvantage. I don't like that, so let's break that down to where people can understand exactly what is going on. Comparative fault means that you are accused of, not necessarily guilty of, but you've been accused of being partly at fault. So what does that mean? Well, let's say that both of you are turning at the same time, or the best place to begin looking at this is probably the left turn, where there's a light, both sides have the green light. One party is making a left turn and they believe that they have control of the intersection, meaning if the other car isn't speeding, then they ought to be able to make the turn without having any kind of an impact. So that's usually what that is. And there's a percentage. It's 100% you start with, so who's most at fault? In most states, it doesn't matter if you're more than 50% at fault because you can still recover that percentage. I'll get into that in a minute. But in Tennessee, let me just start out by saying, Tennessee has modified comparative fault, meaning that if you are equally at fault, if both parties are equally at fault, neither can recover from the other. So in that instance, in Tennessee, the mathematical calculation is 50-50 equals 0. So let's look at that. Let's look at that left turn situation. Under the law in every state, you're not supposed to make a turn, particularly a left turn, unless you can do so in complete safety for everybody on the roadway. But let's say that you do make that turn, believing that you're able to do that without having any impact with anybody else, but the other party is speeding. And let's say they're speeding greatly. So if it's a 40 mile an hour speed limit, let's say they're doing 60. So clearly they have some fault. So the argument would be, let's say that one person is 80% at fault and the other person is 20% at fault. Let's say the case is worth and your claim is worth, let's say $100,000. In that instance, because you were deemed to be 20% at fault, your claim would be reduced to $80,000. And so that is how it is done. In Tennessee, the insurance company will always fight to get to that 50 so they don't have to pay anything. But it would be the same type of split in Tennessee as long as you don't have 50-50. You can have 51-49, and in that event, you could recover 51% of your claim. So if it was 51-49 in Tennessee, you would still be able to recover $51,000 on a $100,000 claim. But one more percent, you get nothing. And that's modified comparative, where most everywhere else in the world, it's pure comparative. All of this points to why you need an attorney on your side helping you throughout the case. And the sooner you get an attorney, the better, because then the attorney can gather all the evidence showing and being able to prove that you are not at fault, either not at fault or that your percentage of fault was very, very small. Let's take the speeding example. We can actually get a black box reading. We're one of the few law firms in this area that actually has the ability to go out and read the black box of the other car. And we can go out and we can find out the speed of the car at the point of impact. So that's very, very critical. Witness statements, MDOT or the TDOT cameras, we can get that. We prove a lot of cases just from video footage from corner stores, like a little Exxon store or something like that. We go get that footage. All of these things are very important to your case and can help prove that you're either not at fault or minimally at fault. And this is why an attorney is very helpful. So before you pick up that phone and start trying to argue your own case with that adjuster, why don't you follow this link right here and let us take a look at your case. We will tell you what we think we can do and what it might be worth. If you don't want to do that, you can call us at 888-WE-FIGHT. We're open 24/7, 365. If you're hurting, we are working. I ask that if you don't want to do either one of those, go to our website, look under the ebook section, and find one of the books that we have up there that will help you navigate your way through this on your own. We're not trying to monetize this. If you're watching this, please give us a like, a subscribe, or a thumbs up. Help us spread the word. We're not trying to monetize this. We're just trying to spread knowledge and lift everybody's knowledge base. So, just to close, I'm John Michael Bailey, John Michael Bailey Injury Lawyers. If you can hear my voice, I wish you peace and joy. And as always, I hope to talk to everyone real soon. 888, we fight.